Well, happy Thursday to you. Bill O'Leary coming to you this Thursday, the first Thursday in January. Happy New Year, everybody. 2022, here we go. Another year. So I hope your 2021 was good and 2022 will be even better. So I'm coming to you live. We call this our Thirsty Thursday series. And again, the idea is that I, as an estate planning and elder law attorney, want to sort of from time to time talk about a topic that may be of interest, some of the things that I see. And so every Thursday I've decided to go live about this time to talk about that, share some of my thoughts, and maybe you can benefit from it or find it helpful. So if you're thirsting for knowledge, you have come to the right place. So okay, today's topic: why you might need a trust in addition to a power of attorney. I'm sure you've heard of a power of attorney. So while everyone should have a power of attorney called a durable power of attorney, or maybe a financial power of attorney, that appoints someone to act for them if they become incapacitated or disabled. In some situations, that may not be good enough. It's sort of a good start, but that may not be good enough. So in those situations, having a revocable trust can help. So a durable power of attorney, again, allows someone that you name, that you appoint as your agent, to step in for you to handle your financial affairs and your legal affairs. And they would do that, let's say, if you become incapacitated. That's typically when a power of attorney would be used. Now, look, we're all at the risk of becoming incapacitated, let's say from illness or injury. Maybe it's temporary or permanent, whatever it might be. And of course, this risk goes up as we age. Now, if you don't have somebody in place to handle your affairs, well, bad things can happen. Well, like what? Well, maybe bills go unpaid. Maybe, a contract that you need to sign never gets signed. Maybe, mortgage payments aren't made on the house, or maybe there's a need to refinance the house. You can't do that. As I said, bills don't get paid. Utility bill doesn't get paid. Maybe your investments go unmonitored and maybe unadjusted if there's a need to adjust it. All of that can happen. So, and worse yet, families sometimes fight over who's in charge under the power of attorney, who's the agent. And the remedy of seeking a court-appointed, what's called a guardianship, boy, that's expensive and cumbersome and very time-consuming. So it's best that you pick your own person or maybe list of people to serve in this role as the agent under your power of attorney. Now, again, as I said, having a power of attorney, although it's an important first step, sometimes it's not enough. Well, why? Well, here's why. Some financial institutions, a lot of times they don't honor older powers of attorney, even though technically under the law they're supposed to. They just don't. That's just a reality that we constantly see out there in the marketplace. And then secondly, an agent that you may name under a power of attorney, a lot of times they don't step in to help you manage your affairs until it's too late. Both of those problems can be solved with a revocable trust. So now let's talk about, let me take a step back and talk about why financial institutions might sort of reject a power of attorney, even if it's sort of a fairly recent one, which is a problem that a revocable trust can solve. But let's focus on sort of that phenomenon that we see that institutions would reject a power of attorney. Okay? So if it's an older power of attorney, they might reject it because they may say they don't know whether that old power of attorney, or POA as we might call it for short, maybe has it been revoked? That's what the institution will ask. Has it been revoked? They don't know. If it has been revoked, then they run a risk in sort of honoring that power of attorney that's being presented to them. Sometimes they'll require the attorney who drafted the power of attorney to sort of give a formal statement, sort of attest to the fact that the document has not been revoked. And maybe the attorney hasn't met with that client for many years. Maybe that attorney is retired or dead. And so we can't get that kind of assurance, at least the institution can't. Institutions are also uncomfortable honoring powers of attorney because they don't want to be held liable for any improper actions by the agent that's appointed under the power of attorney. So This kind of rejection, yes, they're not supposed to do that. They're not supposed to reject a POA. It's really against the law. The reality is that it happens, and there's really no good remedy when it occurs, because look, good luck trying to sue the likes of Bank of America or Wells Fargo or Fidelity or Schwab. Boy, would that be expensive and time consuming. We don't want to do it there. So fortunately, there are three ways to avoid this institutional sort of intransigence, shall we say, this resistance. Number one, update your powers of attorney on a regular basis. Financial institutions are much more accepting of newer documents than older ones. It's almost sort of human nature. So it's a good idea to execute a new power of attorney every 3 to 5 years, frankly. Of course, this can be sort of, a perverse. So, if the power of attorney is being used because of your incapacity due to dementia, let's say, you're more likely to have been experiencing cognitive challenges a year before its use than it were 10 years ago. See the perversity of that? That maybe the one that you did 10 years ago is more valid than the one that you did a year ago, when a year ago maybe you were in declining cognition. But again, as a general rule, it's good to refresh or update your power of attorney on a regular basis. Number two, sometimes the solution is to use the institution's form of power of attorney. So a lot of banks and investment companies, they develop their own durable power of attorney form that they are more comfortable accepting than the general ones that sort of apply across the board. So even though the institution is under the law supposed to accept your power of attorney if it's a good one and not force you to sign theirs, again, that's just a reality that we are seeing out there in the world. So what you should do is contact each financial institution that you have an account with and ask whether they have their own POA form. Now, you're still going to need a general, what's called durable power of attorney, because a lot of these financial institutions form only govern accounts that are held at that institution. And so the POA that may be used at one bank is not going to be usable at another bank. So you really need sort of your across-the-board power of attorney. So, and then the third sort of solution to avoid this sort of pushback by these institutions is to use a revocable trust. The reality is that financial institutions seem to accept a revocable trust much more easily and much more readily than powers of attorney. Revocable trusts have the added advantage that you can appoint a co-trustee, let's say, to serve with you for your trust, so that if you become incapacitated, your co-trustee can step up and act seamlessly. It's really a great solution for incapacity planning, is with a revocable trust. Now, by the way, a trust provides financial protection as well, because as we age, we all become increasingly susceptible to making, think of it as sort of, financial mistakes, maybe falling victim to scammers, a lot of scams out there. Having a financial advocate in place can help avoid those problems. So an important step is to name an agent under a power of attorney. But again, oftentimes these agents don't step in until it's too late, and the individual, let's say they're a senior, they've already lost significant amounts of money. Okay, so that's not good. We don't want to find ourselves in that situation. So, and again, using a trust can solve this, where you can name a co-trustee to serve with you to seamlessly step in and manage the affairs. Okay, so with a revocable trust, again, just to sort of bring it full circle, they often sort of work better for incapacity than a power of attorney. Now, two sort of cautions. Number one, a trust only controls the accounts that it actually holds, that it actually owns. So for the trust to work, you have to retitle the accounts into your trust or have them payable to the trust at your death. Number one. Secondly, even if you have a revocable trust, you still need a power of attorney. They sort of go hand in glove together. So the reason for also needing a power of attorney if you have a trust is, number one, let's say you've not transferred all of your accounts into the trust for whatever reason that based on the attorney's advice, okay? And so if that account has not been transferred into the trust, it's still held outside of the trust in your own name. Well, the trustee has no sort of authority or control over that non-trust asset, that account that's outside of the trust. Who can have authority over that if you become disabled? An agent under the power of attorney. Okay, so that's reason number one why if you have a revocable trust, you also need a power of attorney. Reason number two, the trust only governs financial matters. Your agent under your power of attorney can also handle legal matters on your behalf, including even signing income tax returns. So again, to make sure you have sort of the broadest protection possible, to make sure that people are able to handle or help you manage all of your affairs, having a revocable trust along with a power of attorney, great 1-2 punch, great solution. So look, if you'd like to know more about why you might need a trust in addition to a power of attorney, and maybe if you'd like to know how maybe we can help, we'd love to talk to you. So what we encourage people to do, take an easy first step. Go ahead and have a phone call with us. Schedule a free 15-minute phone call. We like to call it our discovery phone call. Very easy to do, and what that does is it gives you a chance to tell us what's on your mind, and also for us to sort of start to get a feel whether we'd be a good fit for each other. So it's really easy to do. Just go to our website, legacyplanninglawgroup.com, and find the blue button on the top of the website, as well as another one smack dab in the middle on the home page. Book your free phone call. Okay, very, very easy. And again, that call is complimentary. So if you've enjoyed this video, I would kindly ask that if you wouldn't mind liking it, and better yet, sharing it with your friends. Maybe your friends that have not had the opportunity to see this video and you think might benefit from it. So I hope you've enjoyed this talk, why you may need a trust in addition to a power of attorney. So I plan on giving another talk next Thursday, now that we're in the new year, sort of we're back in a rhythm. Next Thursday at about this time, talking about a different estate planning or elder law topic. So if you're thirsty for knowledge, you've come to the right place. So just to sign off here, Bill O'Leary, and on my behalf and everybody here at my firm, Legacy Planning Law Group, we call ourselves Team Legacy. Go make it a great day and make it a better world, especially in 2022.